Thank you very much to everybody for attending this evening's event on whistleblowing. My name is Dr. Conal Mallory. I'm a senior lecturer in law at the Newcastle Law School. I'm also the convener of our Forum for Human Rights and Social Justice, and I've worked alongside Professor Ian Munro to try and organize tonight's event. Today, in the past 15 minutes, we've experienced all the highs and lows of Zoom already. All the lows of people seemingly crashing in, wrong links being sent out, and really getting to grips with something we've been working on with for 2 years. But at the same time, we've got highs in that we're able to actually co-host events like this and bring in people from different parts of the country, different parts of the world as well. And we're delighted to co-host tonight's event, both with our friends and colleagues in Newcastle Business School, but also with the Irish Centre for Human Rights as well. That's all that I'm going to say this evening. As you'll have seen, we have this event recorded and we'll be putting it up on a couple of different platforms. I'm going to pass over to Ian, who's going to chair today's event, and who certainly is the real expert in whistleblowing for this. So yeah, enjoy. Thank you very much to everybody for attending, and over to you, Ian.
Thanks very much, Conal. I'm afraid I'm actually going to have to well, I'm just going to very briefly introduce everybody, and then I'm going to have to try and sort Robert out. He does exist. He's having troubles getting access to the event. So firstly, thanks very much for the Irish Centre for Human Rights and the Newcastle Centre for Human Rights and Social Justice, and the Nubs Business School as well, for all helping out with this event. And the three speakers, Robert Thibault, Professor David Lewis, and Professor Kate Kenny. So Robert is he's an expert in all sorts of and varieties, a wide range of law, from commercial law, employment law, refugee rights, human rights, asylum seeker rights, and he's been involved in a couple of interesting high-profile cases. He was written up in Forbes a few years ago, a case about a scandal about BTG Bank in Portugal. And more famously, of course, his support for the National Security Agency whistleblower Edward Snowden. And he'll be the second speaker today. The first speaker, thanks very much, Professor David Lewis. He's a professor of whistleblowing and law at Middlesex University. He is head of the Whistleblower Research Unit at Middlesex, and he's also the convener of the International Whistleblowing Research Network. And finally, thanks very much for Professor Kate Kenny, who's the Professor of Management at National University of Ireland, Galway, who's written a fantastic book on whistleblowing, which I highly recommend, and is currently co-editing a book on new perspectives on whistleblowing with me and Mariana Fataki. So thanks very much. And I just want to introduce David is the first speaker. Thanks, David.
Thank you very much, Ian. Thank you for inviting me. I ought to make clear that I'm a professor of employment law, not whistleblowing law. I quite like that title, but I don't think I deserve it yet. Can you see the screen, Ian? You all right with the PowerPoint?
Yep, you just need to press play for the...
Play? Oh, well.
Yeah, there's a little PowerPoint slide at the bottom. Yeah, that's it. There.
Okay, is that working? Yeah. I'm going to start. Do tell me if it's not visible. You should see on your screen what I'm talking about. Whistleblowing and social justice. What can employment tribunals deliver? Are you happy with that, Ian? Ian?
Yes, that's fine. There is a slideshow button at the bottom of the screen that you need to press, David, to enlarge it. But it's fine as this. Thanks.
Okay, I'm going to kick off. Obviously, the context here is human rights, and I'm taking for granted, of course, that when we talk about whistleblowing, we're talking about human rights, human right to freedom of speech, freedom of expression. To the extent that employment laws protect whistleblowers, we're talking about labour rights. So we're well in the mainstream of human rights when we talk about whistleblowing. The association between whistleblowing and social justice is very interesting, and I'm going to suggest to you today that one mechanism that doesn't quite work for achieving social justice is an employment tribunal system, a legal system that's been much criticised in the UK, but has been in operation since 1999, and I think quite shockingly so. There've been moves to get away from it, but we have a tribunal system that doesn't deliver generally, and in particular doesn't deliver for whistleblowers. I'm going to take you through that and suggest that social justice may have to be achieved elsewhere, if it can ever be achieved by the law. My own view, of course, is that social justice and whistleblowing is going to occur in a different kind of society, a different kind of economic system, but also whistleblowing can't be regulated by the law. The law has a role in, it has an educative role, it has a role in trying to mould a culture whereby people are able to speak up, they're safe in doing so. And many people say, well, that's not going to happen in the current kind of neoliberal environment. But currently in the UK, the law does play a role. It plays a role in other countries as well. And I'm going to consider what's been achieved via employment tribunals. Important aspect of the UK system and the use of tribunals is that actually the legislation doesn't aim to deal with wrongdoing at all. It aims only to protect workers after they've experienced retaliation. Since researchers have established globally that the reasons why people don't report wrongdoing are, one, a fear of retaliation, but also the belief, well, there's no point in raising the wrongdoing unless it's going to be investigated, unless there's going to be rectification. So people want confidence that if they're going to run a risk of retaliation, at least there's a serious prospect of any wrongdoing that's identified being rectified. The employment tribunal system in the UK does nothing like that at all. It protects once retaliation has been experienced. So the word protect, I think, is wrong in this context. But of course, the word protect's always used in employment law. We talk about employment protection legislation. And I think something protects when it prevents harm being suffered. That's a correct use of the term. So the employment tribunal system doesn't actually encourage reporting in the sense that there's no undertaking, it is not an outcome of tribunal proceedings that the concern will be investigated. That's purely fortuitous. It might happen. Indeed, we get the ridiculous situation where you say to students, well, what happened in this case? Was the individual protected or not? And they can give you an answer to that. Then you ask the question, well, was their allegation true? Was there actually wrongdoing? Well, you can read all of these decisions, and it's very difficult to see in many of them whether somebody was unprotected, but actually what they alleged was true. So the law protects workers in a very loose fashion. It also doesn't attempt to deal with discriminatory hiring, except, curiously enough, in the health service. Discriminatory hiring is outlawed under the Equality Act. Being a whistleblower isn't a protected characteristic, and there's an argument for saying actually being a whistleblower should mean you get protected status in the same way as trade union officials and trade unions have protected status. It's not a characteristic because somebody's volunteered to whistleblow. They've chosen to be a union member or an official or to be a non-member. But it is significant there is no protection at the point of hiring, which does, of course, lead open to claims that from a whistleblower, well, I'm going to suffer discrimination in the labour market because nobody's going to touch me with a barge pole, A, because I was a whistleblower, and B, because of employment tribunal proceedings. For those who are interested, the exception in the NHS, the protection in quotes that is offered there, that emanates from the Francis report, Freedom to Speak Up, and he recommended that, and that was brought into effect. It was pointed out to him that discriminatory hiring is covered in the Equality Act, and it would be invidious just to protect whistleblowers in one sector. Why not in financial services? Why not elsewhere? Of course, Robert Francis, that was his approach, but it was drawn to his attention this was an anomaly. So the Part 4A protects in this way. It provides remedies, but provides different remedies depending on whether you've been dismissed or you've suffered a detriment. Re-employment is not available to workers who can't claim unfair dismissal, but nevertheless suffer detriment. Very, very curious. We can see that there may well be a category of people who aren't employees, they are workers, their work dries up. It may well be that they're seeking something akin to re-employment, but that's not available. Workers who suffer a detriment can get compensation, they can get a declaration for what that's worth. More substantially, those who are dismissed can get unlimited compensation, and they can seek re-employment. They may not want it, they may choose compensation, but on paper, it's down for consideration. And I've noted for you on this slide that under the Equality Act, one remedy that might be quite useful is the power to make recommendations. And in the case of whistleblowers, a recommendation that actually the wrongdoing should be taken seriously, should be investigated, and the perhaps retaliatory measures should be rectified. So here are some of the statistics. Sadly, that the figures are out of date because the Employment Tribunal information is being migrated to a new case management system. I draw that to your attention. But you can see that the number of cases disposed of, as with other tribunal jurisdictions, most cases don't get to a hearing. The vast majority don't get to a hearing because ACAS has the duty to conciliate. It deals with early conciliation certificates, and as a result of its efforts, most cases are settled or withdrawn. We don't know the nature of the settlements in these cases. We don't know the nature of any remedy in these cases, and that, of course, is to be regretted. Similarly, with withdrawal, we simply don't know the terms on which cases are withdrawn. It may be the majority of them are highly successful from a worker's point of view. I doubt it somehow, but it's possible that conciliation is doing a good job for whistleblowers. That needs to be investigated. In terms of success, well, you can see a 3% success rate. And so one reason, of course, cases don't get to a hearing is that people are aware of the success rate. But the success rate is for a number, maybe for a number of reasons. And I'm going to suggest to you that a number of reasons will be what the law actually provides, the structure of the law. So moving on to the next slide, I'm conscious of the time here. In terms of whistleblowers and social justice, we have got the anomaly, and it's an anomaly that's dealt with in other jurisdictions around the world. We've got the anomaly that whistleblowers are protected in the UK if they are workers, which is entirely incompatible with the Article 10 freedom of expression, which gives rights to citizens. So there is a strong case for saying the whistleblowing measures should protect should protect all persons, and other countries manage to do that. In this country, we have great difficulty deciding who's a worker, who's an employee, and in many countries they say, well, we don't need to draw that distinction, it's wholly wrong. But here we draw a distinction between workers and employees, and the wide group of workers, distinct from citizens who seem to have no whistleblower protection rights, but may well be have concerns they want to raise. And illustrations there, of course, the classic ones in the health service, where family members may want to report concerns, but they have no protection if, in fact, they fear there's going to be retaliation. So the legislation is based on the premise that workers need protection, others don't. I've even seen it argued that, and I think it's in the papers, the background papers for the European Commission, where they're saying workers need more protection than other people. Well, I'm sure that's right to some extent, but the idea that whistleblowers generally aren't protected is an unfortunate one. In terms of claiming, the cost of claiming, we don't have a legal aid system in this country that covers this jurisdiction or any employment jurisdiction, to my knowledge. So individuals need advice, support, and representation. It's expensive, and people are going to bear that in mind. The success rate, what is it going to cost me? Trade union members may be better off, but trade unions have strapped for resources, and they too will take hard decisions about who they're going to back in these cases. So I flag up here the notion that there is a role here for a specialist whistleblowing agency that provides advice, support, possibly representation. But the case for an agency, I think, is a powerful one. Such agencies exist in other countries, and just north of the border, we have a independent national whistleblowing office, and it might be worth looking at how that works. So I'm going to come back to the whistleblowing agency later on. In terms of employment tribunal claims, though, I draw to your attention, I've already drawn to your attention the fact that there is mandatory conciliation, the requirement to have an early conciliation certificate, but mediation is a bit haphazard. There may well be judicial mediation, but I've argued, I've written about this. I argue that there's maybe a potential role for mediation in that it allows the attention to deflect from the messenger. It allows an individual to say, look, all I want is an apology. I just want an inquiry. I want rectification, and happy to agree a solution that the wrongdoing is rectified over a period of time. So I think mediation largely ignored. It's a very important, I think, additional dispute resolution mechanism. It doesn't necessarily have to be an alternative one, but I just draw to our attention that we have adjudication, that we have conciliation. Mediation doesn't get a lot of attention, and I guess arbitration is often not going to be appropriate. As regards claiming, everybody be aware about the delays in the justice system. Justice delayed is not justice at all. And I remind you here that the employment tribunal system had, I think, tens of thousands of cases backed up pre-COVID. So COVID can't be blamed for hearing delays. So in terms of the content of the legislation, social justice, well, the notion of a societal interest in this process comes out in the ingredients of what is a qualifying disclosure. And there's a worker's got to reasonably believe that they're acting in the public interest when they raise the concern. This can't be a personal grievance, whatever. What is a grievance? What is a legitimate concern here is obviously going to be open to debate. It's a very odd system to have a public interest test. I'm not sure that there should be a public interest test. I believe there shouldn't. I think the public interest is in reporting a suspicion of wrongdoing. That's in the societal interest, that there is fraud, there is negligence, there is malpractice. I don't think you need a separate public interest test. People don't know how it's going to be met. We've got case law and whatever. But for me, the biggest argument about the public interest test is, what about the private sector. Does the private sector want its staff to report concerns in the public interest? No, it doesn't. It wants its staff to report concerns in the interest of the shareholders. It wants to know about wrongdoing before the share price plummets. So if you look at what actually big private employers do, they don't have a public interest test. They don't. That is for the law. But so far as they're concerned, they have a procedure, and the requirement is what they want people to do, what they encourage people to do, is to report in the interests of the business. So public interest test suggests that, maybe society's got, it links whistleblowing with society's interest. It makes some sense, if you like, in the public sector. In the private sector, I'm not convinced. And as far as I can see, the big firms, the FTSE top firms, recognise that a public interest test may suit the lawyers, but it doesn't suit their interests. Again, is the disclosure protected? Individuals have to have information about who is a prescribed person. They need information about when they can make a wider disclosure. Increasingly, people use social media today, but that's only going to be justified as a last resort. Other requirements for a wider disclosure contain lots of uncertainties. I've just listed them here. But the legislation is based, and Part 4A is the embodiment, if you like, of the Public Interest Disclosure Act, which was a private member's bill that was not properly scrutinised and contains such expressions as substantial truth, exceptionally serious failure. So we get the sadness of people being defeated because a tribunal says what you reported was a serious failure, but in our opinion, this was not an exceptionally serious failure. I think advisors throw up their hands at that stage. It's unfair. It's too subtle. We want people to err on the side of caution. Many employer policies say, if in doubt, report. The legislation does not take that approach. In terms of proving a claim, different burdens of proof. Can anybody explain to me why there should be different burdens of proof depending on whether you claim you've suffered a detriment or dismissal? To me, it's confusing, it's wrong, it's unnecessary, but that's what happens. In terms of the outcome, I take the view in terms of justice, and this is justice in dismissal, if you like, and I think it is an aspect of social justice. I take the view that if somebody is unlawfully deprived of their job, they should choose, should have the choice of the remedy. Only in exceptional circumstances should a person be denied re-employment if that's what they want. It shouldn't be at the call of an employer to throw money at the problem. It should be up to the employee to say, I'll give it a go, I'll give it a trial period. If it doesn't work, I'll take compensation. But if you unlawfully deprive somebody of their job, rectification requires that you give that job back if it's humanly possible. I've got a plug here for Kate Kenny, quite rightly raised the question, well, there's unlimited compensation, but are there some losses that can't be properly calculated? A very important question, and see her work for the answer to that. Curiously, in terms of compensation, the issue of good faith can affect compensation. I think wholly unfair. Somebody's compensation may be affected up to 25% if, although they've been found to have made a protected disclosure and been victimised, somehow or other they didn't act in good faith. I do find that really quite depressing, that one wants to look at them, if you like, the motives, intentions, when the individual has suffered a detriment and has fallen for protection under the legislation. I've already made the point, of course, at the end of the day, where we started, the legislation apparently protects, but at the end of the day, we will know what happened to the messenger. We won't know whether the message we won't necessarily know whether the message was accurate or not. So the focus is on the messenger, not the message, and that is wholly wrong. Whistleblowing is about the message, not the messenger, and at least other countries see that, and the EU directive, I think, is more helpful in that sense. So I'm going to finish on possible reforms. I'll be fairly quickly. I'm aware I've probably taken too long. I don't think there's any argument against requiring employers to maintain adequate procedures. Other countries do it, it's in the directive, and we have a brand spanking new ISO, up-to-date guidelines, negotiated internationally. There's no excuse for that as far as I'm concerned. Other countries do it. There are, if you like, there are oven-ready solutions to this. I don't know why this doesn't happen. More significantly, what about organisational personal failures to comply with statutory requirements? I take the view that the current system, compensation, etc., doesn't work. I think we should be looking at exemplary damages, which is a punishment, that people should be punished. I think fines may be appropriate, and I actually believe that the way you get through to employers who are willing to be recidivists when it comes to retaliation is to provide ultimately for imprisonment. I'm always amused to see in Kosovo that there is specific provision for recidivists in relation to retaliation. And ultimately, I think we've tried everything else. Why not disqualify directors? They're not looking after the interests of their business, and I think that that's a possible marker. Lastly, I can leave these on the screen. What would a whistleblowing commission or office do? I'm suggesting to you there are lots of things it could do. These seem to be important duties. There have been private members' bills. They've been in the House of Lords, House of Commons, and there's even rumour that the next economic and financial crime bill will say something about a commission. So I'm conscious of the time. I'll stop there, Ian.
Thanks very much, David. I'm going to try and make Robert co-host now, so he can, if I can find him. There we go.
All right, Ian, I'm on now. I'm unmuted.
That's great. Thanks, Robert. You should be able to share your slides. Thanks a lot. I've already introduced you, so no need to do that second time. Thanks very much for attending, Robert.
Okay, I'm going to. Okay, just 1 sec. There we go. All right, you're all able to see the PowerPoint presentation now, correct?
Yeah.
Okay. My apologies for arriving late. I was having some technical difficulties, which Ian helped me eventually resolve. Thank you, Ian, and thank you for having me here today. What I'm going to do is I'm going to go through a little bit of history with my involvement with whistleblowers and those who protect whistleblowers, and provide an update on, in particular, the refugees who sheltered Mr. Snowden. The second thing I'd like to do is to address some of the issues that David had raised in his excellent talk, and and how that relates to different issues relating to whistleblowing. Now, just as a reminder, you can see from the screen that I'm a member of the Hong Kong Bar. I also have special authorization from the Quebec Bar to practice law. And I've been the lawyer for American whistleblower Edward Snowden and the refugees who sheltered Mr. Snowden in 2013. Just an update that a reminder that it was in June 2013 when Mr. Snowden was in Hong Kong, and it actually May and June 2013, and made his disclosures about the activities of the NSA and the Five Eyes on global electronic mass surveillance. Snowden's currently in Russia, having secured permanent residency there, and he's awaiting Russian citizenship to be granted to himself and his wife, Lindsay Mills. And to remind you that, but for it would have been 6 of these people, because the little boy on the right-hand side of your screen, Dinath, was not born in 2013. He wasn't here in 2013. He was born in 2016. But the other 6 individuals, the adults and their children, provided shelter to Mr. Snowden in June 2013. And but for their kindness and compassion and humanity, it's doubtful that Mr. Snowden would be alive today or have his freedom. These 6 individuals stepped forward as those seeking to protect a whistleblower based on their own decisions of conscience. Now, just a bit of background and this is about myself as a lawyer for a whistleblower and the Snowden refugees who protected the whistleblower, that immigration and police in Hong Kong and other government departments, including legal aid, duty lawyer service, made efforts since the Oliver Stone film Snowden came out, targeting myself and my clients for having assisted Mr. Snowden in 2013. In 2017, the Hong Kong police made concerted efforts to coerce a number of my clients, some of them who were witnesses in the Snowden refugees' asylum claims in Hong Kong, attempting to coerce them to provide false evidence to be used against me and asking them to testify in a criminal court. They all told the police no, they would not do that, and the main reason was the allegations were false. And in terms of immigration, the immigration department put enormous pressure on me in 2017 and 2018 with the view to have me removed from representing the Snowden refugees. And the legal aid department stopped paying me my fees since for work I've done since 2012. Again, legal aid is part of the Hong Kong government, and they made concerted efforts to make sure that I would not be able to represent the Snowden refugees in any future judicial review or appeal in the Court of Appeal or Hong Kong Court of Final Appeal. And I have not been paid for most of my fees since 2012 and as of today. And this had left me in severe financial distress. And the Bar Association itself had actually, in a 2017 annual general meeting, which I was not present at, made malicious and racist remarks about me for my representation of Mr. Snowden and the Snowden refugees, despite the fact, and there were accusations that I violated the bar code for speaking to the media in advocating, for support for the Snowden refugees. And I'd note that no complaint has ever been made against me by any client ever. And that did not stop the Hong Kong Bar Association from relying on anonymous complaints against me, and without any evidence. They're completely unfounded, and interestingly, the anonymous complaints were made by two large groups of barristers. So I'm just sharing with you, and again, I'm putting this in context of when you have a whistleblower who was at one point a core person operating deep inside of a government agency or even a corporation, the information they have is going to be more likely or highly likely credible and reliable. And Mr. Snowden made decisions of conscience, and again, it was a balancing exercise for him on whether it was in the public interest to conceal the NSA activities, spying on, using electronic mass surveillance to spy on the world population, or it's in the public interest that he should disclose that. And clearly, Mr. Snowden made a decision without any regard to his own safety, security, or his life. And he made those disclosures. And what I've just explained to you now are consequences when, as a lawyer and also as individuals in society, if you step forward to support in any way or protect a whistleblower, right? Now, these are two anonymous complaints from two large groups of exasperated barristers accusing me of two things. One, that I put my clients at risk in Hong Kong by allowing them, and it was their own decision, to speak to the media, and they were portrayed in the Oliver Stone film Snowden about Mr. Snowden in Hong Kong. And the second was that I did all of this with a view to make more money for myself, which is nonsensical, and there's no evidence that I'm aware of to support that allegation. So two false allegations were brought against me by two large groups of barristers from the Hong Kong bar. And I'd just like to point out in these two complaints that the members of the bar made a finding of fact before there were any disciplinary proceedings brought against me, that these persons, the Snowden refugees, would never be able to be resettled in a third country. And they made that as a finding of fact before I was able to be heard on anything. The second thing is the Bar Association itself made the same allegation. And the Bar Council, since that time, has sought to prosecute me in a barrister's disciplinary proceedings. Since 2017, I've asked for full relevant disclosure of all evidence against me. The Hong Kong Bar Council has refused to do so, stating that all the evidence they have against me is either confidential or privileged. So I have anonymous complaints brought against me by large groups of members of the Bar Association who I do not know who they are. They could be the prosecutor, they could be a member of the Bar Disciplinary Tribunal judging me. And they've refused to provide disclosure of the evidence against me, including prevailing case law. There's a case of the Bar Council versus Chu Jennifer Tsang, who had interfered unduly with a high court judge who happened to be the head of her chambers and was previously the head of a chair of the Bar Council in 2017 to 2018. And I've asked for that case law because she was just handed down a simple censure for acts that may be considered obstruction of justice or perverting the course of public justice. Jeffrey Robertson, who has advised me since 2017, had basically pointed out that it was only proper that the Bar Association make a full relevant disclosure. And the constitutional principle is that anyone who's accused of an offense or a complaint has the right of full answer in defense. It's part of the principle of audi alterum partem, which the Hong Kong Bar Association has not abided by and has not provided a fair procedure. Lawyers Without Borders Canada actually communicated with the Hong Kong Bar Council and asked for full disclosure of my file, and the bar refused, citing confidentiality. They pointed out that the bar will protect complainants, despite the fact that the anonymous complainants are anonymous, and no confidentiality confidentiality or privilege exists with anonymous complainants. The one thing I'd like to mention is there is a foundational British case called the Queen versus Bow Street Metropolitan Stipendiary Magistrate. And there's and it states, it was found in that case, this British case, that the fundamental principle is that a man may not be a judge in his own cause. And what the Hong Kong Bar Association has done, and again, this is all through motivations of my representation of Mr. Snowden in the past and representing the Snowden refugees, that they targeted me based on my simply carrying out my job for whistleblowers and those who protected whistleblowers. But the principle is that with the anonymous complaints, the barristers who are on the bar disciplinary tribunal cannot be ruled out as being anonymous complainants. So in effect, the bar has, through its regulatory structure, legislative structure, has adjudicators on the bar disciplinary tribunal that basically it cannot be ruled out that they are the judges of their own cases, basically acting both as complainant, prosecutor, and adjudicator. So going back to Snowden as a whistleblower, what the Bar Association has done is they have sought to compel me to disclose information about my clients, including Mr. Snowden, the Snowden refugees. They've done so through anonymous complaints. The BDT proceedings, the Bar Disciplinary Tribunal proceedings in Hong Kong are all in camera, behind closed doors, in violation of the constitutional right to open justice. And basically, it's the Bar Council seeking to maintain its control over its own information and data and refusing to make any disclosure on the anonymous complaints. But at the same time, seeking to obtain as much information from me. And as Snowden's, as was stated in the film Snowden, that in the hands of a system whose reach is unlimited, but whose safeguards are not. And the Bar Association has simply done the same thing, but on a smaller scale. The late John Cameron, Queen's Counsel in Canada, had commented on my case that as a chairman of a bar would throw away an anonymous complaint like that into the trash immediately. It's hard to believe that there isn't any political design behind these actions. They're just too many coincidences. And Manfred Nock, the former UN Special Rapporteur on Torture, pointed out that the Hong Kong Bar Association current actions against Thibault could only be explained by the fact that probably enormous pressure from outside is exercised. Now, to provide an update on the Snowden refugees. So I'm still a member of the Hong Kong Bar. The Quebec Bar has provided me with special authorization to represent the Snowden refugees. And right now, 6 of the Snowden refugees have been accepted by Canada, by Immigration Refugee Systems of Canada, and now resettled in Montreal. The Bar Association had, as I pointed out earlier, had falsely accused me that my clients were at risk and would never be able to be resettled in a safe third country. I have achieved the task of having my 6 of the 7 clients resettled in Canada. Vanessa and her daughter, the first Snowden refugee family, arrived March 25th, 2019. This is at Toronto Pearson International Airport. And these are pictures taken from 2022 of Vanessa and her daughter. And her daughter, upon arrival in Canada, she's identified as Canadian and is a very happy, healthy little girl. The next family arrived September 28th, 2021. And they are now safe in Montreal, Canada. Sapun, Nadika, and their 2 children. But there's one problem. Ajit Pushpa Kamara, this photo was taken recently in Hong Kong. He's waited more than 5 years for Immigration Refugee Citizenship Canada to decide his refugee claims with Canada. I'm the only lawyer acting for him in Canada, and I'm also acting for him in Hong Kong. And just to give you an update, in late 2021, the Hong Kong Police and Immigration officers, in broad daylight in an afternoon during a weekday in Hong Kong, targeted Ajith and arbitrarily arrested and detained him and assaulted him in front of a watching crowd. They accused him also of holding fake immigration documents. This behavior in Hong Kong by the police, this egregious, if not unlawful behavior by the police, has been escalating since Hong Kong enacted its new national security law, which is part of the basic law. What I'd like to point out is that, and I liked what David, Mr. Lewis had to say. You know, in the context of the employment area, you know, there should be a legislative framework, more comprehensive legislative framework that allows employees, for example, to whistleblow. But what I'd like to comment on, to take a step back, is it's really the role of the executive branch of government and Parliament and the voting population to decide whether whistleblowers will be protected or not. And it really comes down to that. And the reason why I say that is it's all about government and Parliament, what they're comfortable with whistleblowing. And in the law and economics, looking at law and economics, the government may, and it depends on to what extent, want to have whistleblowers and whistleblowing mechanisms because it's in their interests. But what I've found, and I've provided an example with Mr. Snowden and the Snowden refugees, is that if a whistleblower wants to whistleblow on government contact or even corporate conduct that is egregious or criminal, if the government's not comfortable with that, they will never provide any whistleblower mechanisms. They don't want the whistleblowing to exist in the first place. And that's a classic example with Mr. Snowden. Mr. Snowden, and in the area that's not directly or not direct related at all to economics, Mr. Snowden was talking about privacy and in relation to electronic mass surveillance and the issue of unlawful search and seizure, or basically obtaining evidence against somebody in violation of constitutional protections, due process protections. So there, in my view, there's a dividing line here. You're going to see government stepping forward to a certain extent, wanting to protect whistleblowers, wanting to have whistleblower protection mechanisms, but when it's favorable to them, and only to the extent they feel comfortable with that. So that's a huge dividing line that divides whistleblowers in the economic law and economic area to those who are whistleblowing when it comes to human rights violations. And the second thing is those who protect whistleblowers. So Mr. Snowden, and as I mentioned earlier, the Snowden refugees, they all made decisions of conscience that decisions of conscience without due regard to their own personal considerations. And in my view, that is the quintessential whistleblower. And I think the challenge moving forward is really to be engaging the executive branch of government and Parliament and engage them on whistleblower protections, particularly for those individuals who are whistleblowing on core government activities that affect human rights. I'll leave it there, and I'll leave this to you, Ian, to decide how to proceed.
Thanks very much for that very stimulating presentation, Robert. That was absolutely brilliant. Thank you. We'll take Kate's, the final presentation by Kate Kenny first, And then we'll open, after Kate's presentation, we'll open open up the discussion to the floor. So thanks very much, Robert.
You're welcome.
You ready?
Yeah, thanks, Ian.
Right.
And I feel like I shouldn't follow Robert. Thank you for your presentation. But I know there will be a lot of questions that we will be able to answer afterwards. To make connections with what Robert and David have spoken about, what I want to talk about is to continue this idea of areas of secrecy that exist, that are protected as such, and why that is a problem, which is a theme that our previous speakers have mentioned. So I don't have any slides. And I'll just, what I've been preparing for today is just in light of the invasion of Ukraine, and just to express alongside my university president, staff and students our horror at this violence and the assault people are facing on their country. And I've been reflecting on how that relates to the theme of our event today on whistleblowing, human rights and social justice. So when the invasion started, just hard to believe now, a couple of weeks back, Ukrainian officials pleaded with US tech giants. They pleaded with these tech giants to take action in Russia, against Russia, urging them to restrict access to the services of these social media platforms, to curtail the spread of misinformation. And the Ukrainian officials asked them to crack down on Russian state-backed outlets and their activities. There were claims that there were these tech firms were doing work to do this, but they needed to do more. And just a couple of weeks earlier, I mean, I'm speaking to you from Ireland, in late February, we had a whistleblower from Facebook, Frances Hagan, speak in front of the Irish government. Hagan was a product manager in the Facebook Civic Integrity Department. Now, her point was indeed in relation to the escalating at the time situation. And she told the Parliament, the Oireachtas, we call them Media Committee, about her concerns, both with Facebook's reach, but also the secrecy that it maintains about its operations. So as a whistleblower, Ms. Hagan is known, her main allegation is that big tech are aware of the harm of its content that it can cause, and specifically the algorithms, a separate issue, aware of the harm that they can cause and they do cause, but they're ignored because of the profit motive. So she's given explosive evidence on that to the US Congress. So when she came in front of the Irish Oireachtas Committee, she spoke about the role of sowing disinformation and hatred in Russia and the Ukraine. So the algorithm usage, as I'm sure you know, is that platforms have to make choices about the content we see on our screens when we're engaging in social media. And this is based at the moment by engagement-based rankings. So companies get to prioritize the content that's most likely for us to react to. And it tends to give bias, obviously, to content that elicits strong emotional reactions. The strongest emotions being things like hate and fear. They're the fastest path to getting a click. So just by clicking on the content Facebook gives you, Ms. Hagan gave the example that over the course of a couple of weeks, as the algorithm sort of sharpens in relation to your own use, it'll lead you to fairly scary corners of the internet. And her whistleblowing claim is that when she was working as part of Facebook's frontline threat intelligence unit, she could see how Russian accounts using fake profiles tapped into Facebook groups containing potentially 1 million users or more and fed them diets of incendiary propaganda. And her point was that Russia exploits this policy, profit maximizing policy on the part of these firms, to fuel divisions in the Ukraine and weaken democracies worldwide. And Imran Ahmed, chief executive of the Center for Countering Digital Hate, confirms, in his view, the justification for the war against Ukraine was built on Facebook. So for Hagan, though, the problem is this culture of secrecy in Operation Facebook, which is a little different in flavor to other social media companies. Nobody but Facebook insiders has the ability to identify what she calls these influence operations run by countries such as this, And of course, I must say Facebook vigorously rejects these charges, saying they're not true, although there has been studies to show that you know, the content that was being ostensibly labeled by the firm just last year was not being carried out as it was supposed to be. So this is quite relevant if you're based in Ireland or the UK or indeed Europe at the moment, because the debates are going on. Much of this big tech is located in Ireland, and what that means is the regulatory, the supervisory authority is located in Ireland. So Ireland playing a major role in this. But, you know, in the context of what we're talking about today, here we have an insider, a whistleblower coming forward. And really, this person is one of the only legitimate sources of information about Facebook's role in this invasion that we're seeing at the moment.
Right,
Yasmin? So we're seeing these most egregious, serious violations of social justice, of human rights, of violence. And the question is then, what happens when what is facilitating this violation of rights? And what is facilitating is the creation of secrecy havens that can be exploited by people and parties looking to hide activities. So on the one hand, then we have big tech. There's a second story featuring Ireland, and the UK is a big player in this. And I'll just mention the financial sector. Obviously, we're hearing so much at the moment about the role of oligarchs and the project to chase them down and track them down. But this is not a new story. We've noted the last 2 decades saw an explosion of tax haven leaks, waves of documents from whistleblowers showing the details of Russian and other offshore wealth and the sheer scale of that wealth. We saw the Panama Papers, for example, showing up how offshore shell companies are used to dodge financial sanctions. Secretive offshore structures via Switzerland, helping to funnel billions from state-controlled banks to fund yachts, ski resorts, weddings. We've heard all of the stories. We've had the Paradise Papers, the Pandora Papers since then. We've had these revelations and leaks showing links to Western political parties from Russian interests. And of course, I mean, the point is, it's not only that these tax havens are responsible for reducing the funds that are available for public spending by government, but they've played a key role in destabilizing the global financial system more generally, facilitated by offshore tax havens and the role, for example, they played in the 2008 financial crisis. So if we look at Ireland's role in this again, and the UK also, TI Ireland describes how much of the proceeds of corruption, including from countries in the former Soviet Union, are being laundered through Ireland, or I should say Transparency International Ireland. And the Tax Justice Network has been providing information on exactly the ways and the mechanisms and the loopholes that are being used and how these might be addressed. In terms of sort of the scale in Ireland, Ireland being a tiny country, obviously, there was a study in 2017 by Trinity College academics Stewart and Doyle, noting over 100 billion euros has been moved through special purpose vehicles in questionable circumstances on behalf of Russian banks and major state energy companies. So they use these opaque trust ownership structures to disguise who the ultimate beneficiaries, the real owners of the activities are. So there's a lot of information on this, and why is it not available? Typically hidden behind a paywall, or there are parties that have the power to access the data but don't have the resources to do anything about it. So again, just akin to what we were talking about in big tech, we have this secrecy haven. We don't know at the moment much at all about the level and the scale of this wealth, of these oligarch assets that form the focus of so much news today. The transparency is so core. But here again, the focus turns to whistleblowers. Why is our only information on what I've talked about in big tech and finance coming from these leaks, these information from workers in these companies and the odd study here or there? The point is that, you know, as long as the whole system remains opaque and beyond scrutiny, these just act as another form of secrecy, another place that this kind of can be exploited. And it's a bit bizarre because if you think about the narrative of sort of the Western nations that we're describing, they exist in countries that on the surface talk a lot about free speech and transparency. So what is the response? You know, I mean, debates are strong on this. If people are interested in showing solidarity with the people of Ukraine, surely closing off secrecy havens like this and working to stop the flow of funding into the invasion is a key issue. So the first mechanism, I guess, is regulation. I mentioned that sort of Ireland is at the forefront of things in terms of big tech. So the big talk at the moment is around the EU Digital Services Act, which is a technology regulation act that the European Union is proposing. So Ireland plays a role at the moment in regulating, but has been in the spotlight for not having the resources and arguably the political will to adequately regulate. And so the call at the moment is, when this Digital Services Act is coming in, that the responsibility needs to be diffused across the EU, that it is neither appropriate nor going to be effective to have one small country engaging in this kind of regulation. Just to give you an example, I mentioned at the start the algorithms and the operation of those being one of the key issues. And the narrative often goes to the content and the dangerous content, where really it's the system and the processes that are used to feed the content that are almost more dangerous and important to address. So if the regulator that's proposed is going to address those, there's only an estimate about 200 or 300 people worldwide with the experience to be able to take on that kind of role of algorithm expert in a regulatory context like that. Their salaries are typically, you know, $500,000 or more dollars per annum. So this is expensive regulation activity. And so the argument is it does need to be sort of diffused out beyond one small country. Similarly, within Europe, financial regulation has been, shall we say, poor. But obviously now, in terms of tax havens, we're seeing this big focus on the transatlantic task force, for example, to freeze and seize the assets of officials and elites with close ties to the government. But it took an invasion, and this, as we know, has been going on for years. So, I mean, to be honest about it, the situation is that these secrecy havens are provided because they return a profit. I mean, there's a whole ecosystem around these firms. Big tech obviously creates jobs, and to a certain extent, well, to a large extent, tax returns for a country. Solicitors, accountants, investment management firms, there's a whole ecosystem around financial entities enabling this kind of secrecy, allowing it to happen. And so, you know, there's interest in it. So I guess it's a key thing that if we want to hold these things to account, if we want such task forces to work, we kind of have to face the fact, the sort of paradoxical fact, that these secrecy havens exist in a wider economic system that that prizes on the surface openness and freedom to trade and freedom to invest, but at the same time there's these sort of parallel secrecy operations, and that's the situation that we're in. The second, just briefly to mention, mechanism obviously is the area of lawfare against public criticism, and I think, you know, Robert's presentation viscerally brought that home, the strategic use of the law in terms of, in order to maintain various forms of secrecy. Just a couple of weeks ago, you might have been following the case of Harper Collins. So Harper Collins being a massive publishing outlet that was fighting off lawsuits against two of its authors. One was the author of Kleptopia, How Dirty Money is Conquering the World, Tom Burgess, and another, the author of Putin's People, Catherine Belton. So they were both being sued for what Harper Collins would have called fairly tendentious claims around defamation, and but sued by quite, how would you say, focused entities using these kinds of law techniques known as slap suits. So these were strategic lawsuits against public participation, according to the defendants in it. They termed them as that because they were lawsuits that were, you know, not so likely to succeed, but also were powerful enough to go on for a long time and to exercise a lot of concern on the part of the defendants and to wear them down. And the thing about slaps, if you're following the calls to close off those legal loopholes, what you'll notice is the famous cases that manage to defeat slaps, there's usually huge money behind them. So for example, Harper Collins, which managed to succeed in its defense, if you like, of its two authors, Burgess and Belton, they are funded by, or they're owned by News Corp. So this is quite a large pot of money, shall we say. Another famous case is the US talk show host John Oliver, who was also targeted by a slap, but he had HBO, the TV network, behind him. So it makes one wonder, well, you know, what chance at all would an ordinary citizen who's been targeted from a slap suit, if the ones that you look to as successful have really significant financial backing to them. So, I mean, you know, at the center of this is whistleblowing, and a key, as David pointed out at the start, to whistleblowing rights and their capacity to speak up is the human rights discourse and the human rights debates. Even the EU Directive 2019, which is famously has brought in significant improvements for whistleblowing in terms of protection, cites obviously the Convention for the Protection of Human Rights as it's in its kind of a preamble. But as always with these things, and again, David brought this out, that the key will be in how the EU directive, in terms of its ability to protect workers' rights for speaking up, is implemented both by member states, because there's a little bit of discretion in how member states take this up. There are certain things they can include, certain things they may not choose to include. So that's a big issue. But massively, anyone who's working in this for any length of time, this area, it's organizations taking their obligations seriously, which is another really key issue. You can have the nicest law in the world, you know, mandating robust speak up systems, mandating no retaliation against whistleblowers, must compensate a whistleblower if they win their claim. And there's organizations that just don't do those kinds of things, even though they're in law. And where's the downside for not fulfilling your obligations? So it's those, and I think Professor Wim van der Kerchove has written on that, and the detail is in the implementation of these things. So that will be a really key thing. So, I mean, what you have is a situation where regulation and oversight, where it fails, whistleblowers will always come forward, because there are always going to be workers who can't stay silent and just will speak up. And so in the failure of regulation and law, you're creating human shields out of those people, because they are effectively acting in the space that the regulator is meant to be acting in. So you have one individual and their family taking all of that risk, where the regulatory authority and the oversight authority should be, which is, you know, an unjust, to say the least. So what to say about it? I mean, just to close, there are organizations worldwide that are doing incredible work in two respects. I guess there's organizations who are brilliant and working hard to provide legal advice and solid practical advice to people who find themselves in those situations, like Transparency International Ireland, where I am, like Protect, like GAP in the US, Blueprint for Free Speech. There's organizations, including some of those that are lobbying incredibly hard to change the law, to not have good law repealed, which happens, and to change the culture, to make whistleblowing something that's normalized on the agenda for people, that it becomes quite normal. But those kinds of organizations often struggle for funding. I mean, it's not something that's easily attained. And so many of them are doing huge amounts of work with this against a limited funding background. And we're also seeing interesting networks of whistleblowers using technology to connect with each other. We're using and to connect with journalists, as we saw in the case, for example, of the Panama Papers, but more recently, whistleblowers in big tech connecting through the Tech Justice Collective and the Omidyar network, so that they can organize through that way as well. So I'm not saying that these are any kind of easy solutions or, you know, quick fixes or anything like that, but they are things that I guess are happening. But I mean, the macro picture and the big picture is just returning to this point about human rights and social justice. I think today, if we're interested in those topics, we need to be identifying these new and different sources of justice and of absence of justice, whether it's economic justice, tax justice, justice related to tech and its use. We need to ask questions really about the paradox in an economic system where transparency is valorized, but secrecy is protected in some cases. And, you know, is that circle easily squared? It's not so clear. So these are some questions I think that the terrible events around us are raising and connect us to kind of human rights and social justice. So I'll leave it there.
Thanks very much, Kate. That was a really interesting presentation, and 3 excellent presentations on the issue of whistleblowing, human rights and social justice. So I'll throw it open to the audience now. Could you raise your hand if you want to ask a question of any of the speakers or of all of the speakers? And I'll nominate you if that's okay. If you could raise your hand.
Deathly silence.
Any questions?
Guy Huber's got a raised hand.
Guy, can you unmute yourself? Thanks.
I can't see. You can see me. Am I here?
You are.
Okay, sorry. Well, thanks. That was really, really interesting. I suppose I've just got a practical question. And because just today, I was reading a story about how Client Earth are taking a corporation share to court as a shareholder. And they were saying that if Client Earth lose, then they'll end up bankrupting themselves, because they'll then be forced to pay all of the legal fees, etc., etc., etc. So I know it's just a practical question, but I mean, it seems to me, how can we create funding streams that sort of level up the playing field, and also how can we instigate oversight of the court proceedings? Because in the case of Assange, I mean, the decision that's been made by the judge seems to contravene the law. I mean, maybe that's just my interpretation, but it seems to me that the first thing is practical, and the second is a kind of far-reaching critique of the establishment in this country.
Thanks, Guy. Would any of the speakers like to address Guy's question?
Can't have to fill that silence, Ian. If I could just come back, I mean, you know, there is no, we need a system, there's no oversight of the courts. We don't have a person who's charged with overseeing the legislation or the rights of whistleblowers. We have a Equality Human Rights Commission that really isn't very strong on whistleblowing, as far as I can see. So addressing also the question of funds, you know, there needs to be a decision taken that if society, and this is the system, wants people to speak up, and of course I should have said it doesn't want people to speak up about official secrets, that's out with our legislation here, that's a criminal offence. If society wants people to speak up, it's got to tell people their rights, and it's got to put money into the whistleblowing activity. There's got to be an oversight body that's got funds that can actually that can use them, that can provide representation. So we need oversight of what's going on, and with all of this, you know, you have to have a budget. I think it is ironic in relation to the economic and financial crime bill. There were amendments put down which were not accepted, but I still believe what's on the cards is a commission to protect whistleblowers who are going to report on economic and financial crime, which is going to leave everybody else without support. So these are choices that government makes. But as far as I'm concerned, there's a gaping hole in our system, is that nobody looks at the regulators, nobody puts money into the notion that whistleblowing is in the public interest. You know, the business case is made out, the societal case is made out, everybody's in favor of it, whistleblowing, as long as it doesn't particularly harm them. But as other speakers have suggested, you know, governments are quite happy, but we have this lacuna where when it comes to official secrets, state security and whatever. And one of the things we haven't addressed that probably I should have addressed is that we've got to have a system whereby people can report where there's wrongdoing in relation to the government. We've got to have a system that says, all right, you can't use the normal channels, but if what you're reporting is covered by the Official Secrets Act, there has to be protection for that, and we have to know about it. So I've given a rather long answer, and let others come back in.
Can you unmute?
Sorry, Robert, I think, if you want to unmute.
Yep. The UK has a parliamentary supremacy democracy, and ultimately it comes down to those individual human beings who are elected, and it's up to them what laws they want to pass. It's as simple as that. And the thing that's that I have taken note of since I last spoke at University of Newcastle is, for these types of conferences, I mean, the students are not showing up to listen. They're not showing up to participate. Democracies work when the population participates, not just at election time, but every single day. So when you talk about sort of oversight, I do agree with David Lewis, Mr. Lewis, that, you know, more needs to be done on the oversight side. But is it not up to the general population? My impression is there's limited media coverage, for example, of the Assange case, very limited. Those who have tried to provide greater coverage have ended up being targeted by the British authorities. I mean, and when you, so it really comes down to what the British population wants, and whether they're engaging the people they're electing to represent them in Parliament. As to funding, it's also my observation that people don't want to donate to causes where they may put themselves at risk. Okay, people don't want to donate to unpopular causes where they may be criticized publicly, may have problems in their workplace, may have problems with their friends and family. People tend to donate for, I like to relate this, use an analogy of when people go to the store, they make impulse purchases for chewing gum and chocolate bars. The Snowden refugees, I've raised over $500,000 US for them since 2016. Many years of efforts and conferences and work and trying to advocate for people to support those who protected Snowden. But you can go online and somebody gets insulted in a coffee shop for the way they look or the way they sound. And the next thing you know, there's a GoFundMe page and there's $100,000 or $200,000 US donated to them. So people tend to be very fickle. They tend to be wanting to donate to something they can relate to, and it's an impulse reaction. So I think there's a complex issue about wider society. Do they understand what whistleblowing is? Do they appreciate how important it is? Because most of the time, whistleblowing is not going to be an impulse thing. And the powers that be, the government and big corporations, they're usually not in favor of they're not in support of the whistleblowers. I'd like to mention one thing, Kate. You talked about all these whistleblower individuals and whistleblower organizations that like Transparency International. I'm a bit confused here. There are individuals who may leak information and remain anonymous. They're not whistleblowers. There are organizations that, disclose documents, they leak them, but they're publishers. They're journalists and publishers. And then you have individuals who disclose information like Mr. Snowden, who make decisions of conscience. These are enormous decisions, and they get to a point where they make a decision to make these disclosures, even though there's enormous risk to their life, liberty, and security, and they step forward and do that. I do not see any significant whistleblower over the last 5 years existing on this planet who has stepped forward like Mr. Snowden. The lady who whistleblew against Facebook, I'm wondering why she didn't whistleblow 10 years earlier, 5 years earlier. Why did she wait until she was invited by Congress in the US to talk about all these things? And again, it comes down to what I said earlier, that there seems to be a dividing line between whistleblowing that the government supports or to some extent is comfortable with versus the individual whistleblower where they're going to disclose egregious and criminal conduct of a government department or a corporation, and there's absolutely no protection for them, and they go through this process of decision of conscience. So I'd like to hear what you have to say, Kate, on that, and also David.
Well, I think yes to the absolutely, Robert, and thank you for the question and the clarification. And I appreciated very much the part in Mr. Snowden's book where he said, I thought about leaking this, or there was a moment where I thought this information needs to get out, but it is vital that my name is associated with it and I take the consequences of that. And so it was also the decision to work with established media organizations that were going to be able to help filter the information and present it in a certain way. Those decisions were explained, which for anyone who's interested in whistleblowing or studies it, are key differentiators. And absolutely, when it comes to, I guess, anonymous leakers, and yes, I take the points around the Facebook whistleblower, and there has been articles about the extraordinary support that she receives, not only from political circles and media circles and those sorts of things, but I think I tend to take the point, what is it that they're saying? What is the information? Is that information in the public interest? Is that information important? And to focus on that. And that's kind of the key thing. It is also interesting and important to look at the context, but in the case of what she's saying and the leakers, it's the information that we now know because of their actions that is also important. So that's just to add to the discussion, I think, around the different categories, if you like.
If I just may comment, there's a former soldier in Hong Kong named Ajit Pushpakumara. He's my client. I represented him for 10 years. He saved Mr. Snowden's life. And I've had to watch Canada and other countries bring in refugees from Syria, Afghanistan, now Ukraine. Everybody on this planet has jumped the queue ahead of this poor man who's been abandoned in Hong Kong by the Canadian government. But his case is still live before IRCC Canada. I'm still fighting for that case. To compare the acts of Ajit Pushpakumara stepping forward as a decision of conscience, no different than a whistleblower to protect Mr. Snowden, to compare his actions and actions of conscience to the individual who had the world's support and government support to go before Facebook, to me, there is an ocean that divides the two. And my big question again is, why did that individual not step forward 5 years ago or 10 years ago? Now, my view is that she's not a whistleblower, okay? My view, whistleblowing involves this decision of conscience, okay? And timing is not an issue. You're not supposed to be waiting 5 years or 10 years when it's safe for you to speak. The whole concept of whistleblowing is that you speak when the danger is there, when the necessity is there. And I hope that the message from Ajit Pushpakumara is not lost or diluted by celebrated whistleblowers like the whistleblower for Facebook, against Facebook.
David, did you want to come in as well, please?
I don't exclude anybody else from the audience, but I mean, I think I disagree a bit with Robert on this about who is a whistleblower. There are all kinds of definitions: leakers, bell ringers, whistleblowers. Does it really matter if people are doing the right thing? I'm really not too sure. Also on the timing, if somebody chooses the time, they choose the time to reveal something because they're fearing retaliation. They choose the time that suits them because they see job opportunities elsewhere. We've got to bear in mind, well, all right, they did actually blow the whistle. Ideally, they could have done it earlier, but they could also have remained silent. They've actually blown the whistle. So I understand that ideally we want people to report as soon as possible the wrongdoing, but we understand the reasons why they don't do that. As far as I'm concerned, better late than never. Also, something that probably ought to be mentioned. Robert was saying he doesn't know of other, whistleblowers in the same way. I don't think we should be comparing whistleblowers of conscience necessarily with people who are, not quite as conscientious, but nevertheless performing a useful role. This session of whistleblowing, I'm always going on about this, and please forgive me. People who know me will know I always go on about it. But whistleblowing does not equal retaliation. There is such a thing as successful whistleblowing. There is such a thing as effective whistleblowing, where people raise a concern, they don't suffer retaliation, wrongdoing is dealt with. So the fact that we don't know about whistleblowing could be for a variety of reasons. I actually blame the press, I blame the government for not selling the issue of whistleblowing. I think they've got a lot to answer for. But I think we can't have any conference, we can't have any event on whistleblowing without pointing out that there is I would argue, research demonstrates clearly that most people don't suffer retaliation. A significant proportion do. Far too many do, but we're not going to hear about successful whistleblowing in the banking industry. They're not going to tell us that there was wrongdoing and they've dealt with it. Why would they do that? Anyway, I'm conscious of the time. I shall let others come in.
Thanks very much, David, Kate and Robert. Are there any further questions? We've only actually dealt with one, but in a great detail. Anyone else want to ask anything else?
I just would like to raise one more case about timing. David, I never said that those who step forward to disclose information, particularly of any conduct that's unlawful or egregious or wrong, it should not be done, or it shouldn't be commended, of course. I'd just like to give the example of the residential schools in Canada over a century with tens of thousands of First Nations children taken from their families and had died, their families never being notified. That went on for a century, and it took a century before this started coming out in the open. I think that was a bit too late.
Yeah.
So I just like to raise that point, that I think timing is important, because whether we know it or not, there are other countries in the world where people are adversely affected and may be at risk of losing their life and liberty. And not just what's happening inside Canada or the UK or the US. Yeah. So I just would like to raise that point on timing again.
One final question, or I know we're slightly over time.
Time to go.
In that case, can I invite Shane Darcy, who is representing the Irish Centre for Human Rights, to say something about the whistleblowing, human rights and social justice. Is that okay?
Yeah, no problem, Ian. Thanks very much. And I won't keep people too long. I know it's the end of a long day, but really thank you for the opportunity to participate and for the centre to co-host the event. It's really a fascinating and a highly topical discussion that at some levels of international human rights law, we don't see sufficient attention on whistleblowing. Clearly, whistleblowers are a key and one of many components of a healthy, free and democratic society, but existing alongside other elements as well. And the question by Guy kind of prompted me to think, you're asking who is going to fund these cases or who's going to oversee cases that are happening. And it reminded me of a comment I heard from the Deputy High Commissioner for Human Rights recently that talked about whistleblowers alongside human rights defenders, anti-corruption actors, as well as independent judiciary, free and independent media as playing a significant role. And she was talking specifically in the context of corruption. And we can also add civil society organizations like the ones that were mentioned by Kate earlier. But one of the themes that I thought emerged in the presentations was really the private sector. So David would refer to their opposition to whistleblowing, Kate talking about big tech and big finance. And from a human rights perspective, the international human rights system has struggled to meaningfully engage with the private sector. So our traditional human rights treaties don't address business enterprises, and it's only in recent years that we see attempts to try and frame some sort of responsibilities for both states and companies in this sphere. But it's been a struggle. We had the guiding principles on business and human rights that were adopted and that point out some of the problems that exist, but really they're a kind of an optional guidance tool. And the efforts to have a treaty developed in recent years have really been pushed from the global south and pushed back against by the EU and other Western nations. But we can look at how human rights law as it exists does protect whistleblowers, and which I thought was very interesting from Robert's presentation, those around them, because often the protections for whistleblowers may be quite narrowly focused. So we do see within the UN human rights system frequent reference to protections being needed for whistleblowers, talking about fair trial issues, talking about freedom from torture, etc. But often it's in an ad hoc and a sort of a piecemeal basis. You might find an occasional reference in a country report by a UN expert, and sometimes occasional references for a need for reform. So we had a human rights defender special rapporteur visit Ireland a few years back and specifically recommended legislation to protect whistleblowers. But we have no comprehensive treaty at the international level. We have no special mechanism that deals with whistleblowers within the UN human rights system. We have it for human rights defenders, for example. And Alfred de Zayas, who is an independent expert on what's referred to as the promotion of a democratic and equitable international order, has actually made quite a few far-reaching recommendations, talking about legislation at the national level, but also a charter perhaps at the international level. He made this recommendation in 2016, and I haven't seen that it's gone anywhere since. There are, of course, problems around implementation that Kate mentioned, and I really was taken by her comment about whistleblowers as human shields. We have rules in international law about human shields in armed conflict, but in this context, there's clearly gaps and failings that need to be addressed. So I really appreciate the opportunity to join and follow the meeting and to offer a few comments at the end. So I'll hand back to you, Ian. Thanks very much.
Thanks very much, Shane, and thanks for those very insightful comments. I'd like to add just one brief point that Julian Assange, of course, is currently languishing in prison, and numerous United Nations human rights lawyers have spoken out against his treatment, including Alfred de Zayas, Mads Adonius, Niels Melzer most prominently, and they've been ignored by over many years by the UK government. Shocking treatment. It's not just whistleblowers, of course, it's people who support whistleblowers. That was the focus of Robert's very insightful presentation. But thanks to everybody for all the three presenters for three very stimulating presentations. Thanks to the Newcastle Centre for Human Rights and Social Justice, and thanks very much also to the Irish Centre for Human Rights as well. Thanks for everybody, and for everybody to turn up and participate and listen to these very important messages. So thanks a lot, and bye.
Thank you, Ian.